Hello, everybody. Oof. Hi, Eva. So, Eva. Oh, duh. Those are cat treats. Oh, God, guys. I am so sick. Here you go, Eva. Yeah, I can. It's so hard to breathe right now. It's turning off oxygen to my brain. Yeah, whatever this is, it's nasty. And I got my nebulizer out. Been relying on that and my inhalers, and this is awful. This is truly awful. Like I feel like my lungs aren't processing oxygen. Like that's how it feels. It's oh man. Like I can't like take a deep breath. Like they don't open up. They just don't open. So that's where I'm at with that. Oh. Hello, Buzzy Pug. Hello, Linda Applegate. Well, it's really early. Really, really early. Oh, see, I'm reading one comment while having a different one up on the screen. And I'm replying to the one I'm looking at that nobody else can see but me. Oh my God. And I probably have a fever. I don't know. Oh, this is not good. Oh, I don't know if I said if I was still sick, like as a whole. Like I think it was if I got worse. And honestly, this isn't. I mean, this sucks, but it was worse yesterday morning. As far as like the pain in the lungs, it felt like I had, like gremlins with really long claws, like crawling around in my lungs yesterday. Today, it's just hard to breathe. Oh, you quit your meowing. So, I don't know if I agree. Thanks. Hi, I love you too. I am seeing you. All right, guys. I just wanted to come on and watch a video in case I did go in tonight. Yeah. It's a possibility. So, I just know here's the problem. If I go in, they're gonna admit me. They're gonna. They do it every time. Well, I know, but if it's viral, there's absolutely nothing they can do. I'm already past the point of taking any antivirals for them to be effective. And if it's the dreaded 19, there's nothing they can do for that either. Like all they can do is monitor me. That's really it. And I have the nebulizer here. I have the inhalers, I have everything that they have. So don't. It's probably contagious. Oh, you mean like a driving ticket or a ticket to come see me? Like, what kind of a ticket? A ticket to a rock concert? Oh, a speeding ticket. Well, how'd you get out of it? My goodness. Sounds like Sir Isaac is at the wheel again. He's got a muscle car and he drives around this block because his mother-in-law lives somewhere near me. So I have to listen to that a lot. All right, I'm going to put the cases on.
State of North Dakota versus Kristen Alley Rambo, files 02-2025 CR 171, 02-2025 206. Attorney Trent Jackson appears in the Barnes County courtroom on behalf of the state. Defendant Rambo appears by reliable electronic means from the Cass County Jail. The court notes that on file 171, Attorney Erica Chisholm has been appointed to represent Ms. Rambo. Ms. Chisholm appears by reliable electronic means from her office in Wahpeton, North Dakota. On file 206, this is an initial appearance, and so on 206, Ms. Rambo is currently unrepresented. Ms. Rambo, were you present in court when your rights were read today?
Yes.
Did you understand your rights?
Yes.
One of the important rights you have is the right to be represented by counsel at every stage of the proceedings, including this one. On file 171, today is a bond hearing. On that file, you have been appointed Ms. Chisholm. On file 206, that is an initial appearance. On that case, you have not yet applied for counsel. What is your preference for how you proceed with respect to your right to counsel on file 206?
I would like to apply for an appointed attorney, please. Excuse me.
All right, you are going to be required to submit a new application. Nevertheless, based on your previous application, the court is I'm going to find that you're indigent.
Okay.
I'm going to appoint public defense counsel, and for today's hearing, I'm going to appoint Attorney Erica Chisholm. Ultimately, the commission might appoint a different attorney, but nevertheless, I am appointing Erica Chisholm to represent you at today's hearing in light of her previous and continuing relationship with you in file 171. All right, so we're going to take up the new matter first, and then we'll take up the bond in both cases because the court's intention is to consolidate bond between the two files. So, ma'am, have you received a copy of the charging document in file 206?
I think so, yes. Yeah. Yep.
Is your name spelled correctly on the
Yes.
upper left-hand corner of that document?
Yep.
You have the right to have that document read to you in its entirety, or I can summarize it for you. Are you okay with the court summarizing it?
That's fine.
The state alleges that on or about July 15, 2025 in Barnes County that you committed the Class A misdemeanor offense of violation of a disorderly conduct restraining order because a restraining order was put in place in file 02-2025 CR 57 prohibiting you from having contact with Jody Taylor, and that you on or about that July 15, 2025 date in Barnes County willfully violated that order by texting Jody Taylor, who is a protected party. As charged, again, that is a Class A misdemeanor. It carries with it a maximum possible penalty of 360 days in jail, a fine of up to $3,000 or both. The state has not alleged any minimum mandatory penalties except the requirement that you submit fingerprints if you're convicted of the offense. Associated court fees with that offense total $325. If your conduct causing a loss or financial harm to another person, the court can order restitution. If you're not a United States citizen, a conviction for this offense does carry with it significant adverse immigration consequences. It might also carry with it significant collateral consequences for which the court is not required to explain. Do you understand the nature of the charge and penalties as I've read it?
Yes.
Do you have any questions about that charge or about why you're here on that case?
No.
In misdemeanor level cases like this one, I am going to take a plea of either guilty or not guilty. If you plead not guilty, we will simply set your bail on that file and schedule further proceedings. If you plead guilty, there won't be any trial of any kind. You'd be waiving the rights that were read to you before, earlier today and at previous times that you've been in court with me. And you would likely be sentenced today. Do you understand what happens if you plead guilty?
Yeah.
Do you understand?
I do understand. Sorry. I would like to just plead guilty. I'm not going to argue the charge. Yeah.
We'll talk about that in just a second.
Thank you.
So, Ms. Rambo, do you want time to speak with Ms. Chisholm before you enter a guilty plea?
I guess it's not a big deal to me, but sure, it wouldn't hurt, I guess. I don't know.
So what I'm likely to do under those circumstances is simply enter a not guilty plea on your behalf and give you some time to speak with Ms. Chisholm. And if you still want to enter a guilty plea, Ms. Chisholm can contact the court and we'll set up a change of plea hearing after you've had a time to speak with her about what you're doing, okay?
I think at this point, I think it would be best to just plead guilty. I'm not in the wrong, or I was in the wrong. So I did text those messages. I was just looking for help for my kids. That's all. I probably shouldn't have, but looking for family support. So.
All right. So do you understand that you have the right to plead not guilty and have a trial?
Yes.
Do you understand that if you plead guilty, you're waiving the right to a trial of any kind to a judge or a jury? In a jury trial, this is a misdemeanor, so that means there is a default jury of 6 persons, but you could demand a jury of 12 persons, and all jurors, whether it's 6 or 12, would have to agree that you're guilty before you could be found guilty. You're waiving the presumption of innocence. You're waiving the requirement that the state prove you guilty beyond a reasonable doubt. You're waiving the right to confront and cross-examine witnesses against you. You're waiving the right to remain silent or to testify for yourself. You're waiving the right to present witnesses and evidence on your behalf and to use the court's subpoena power to force those witnesses to appear. You're waiving any and all defenses that you could have had. You're waiving any and all non-jurisdictional defects in the case if there are any, and you're limiting your ability to appeal the case if you enter unconditional guilty pleas. You understand that?
Yes, sir. I do.
And do you still want to plead guilty in that case?
Yes, Your Honor. Yes.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to plead guilty?
No.
Are you pleading guilty because you're doing so knowingly, voluntarily, and intelligently?
Yes.
Do you need additional time to speak with Ms. Chisholm about your rights, any potential defenses, the pleas that you're offering, or the potential for the court to sentence you?
I don't think so. No. No.
All right, so to the single count, violation of a disorderly conduct restraining order alleged to have occurred in Barnes County on or about July 15, 2025. To that count, how do you plead? Guilty or not guilty?
Guilty.
Factual basis, Mr. Jackson.
Your Honor, on or about July 15th, 2025 in Barnes County, North Dakota, the defendant, after being served a restraining order in case 02-2025-CR-57, willfully violated that order by texting the protected party, that protected party being her mother, statements that were contained in those text messages included, I need you to check on the boys. I need them to shower and clean clothes. I'm in treatment. Sean works. Please don't call the cops on me protecting you. I need you. Absolutely help them. They are not showering. They are not doing anything. They're living in filth. That message goes on. But there's also another message that said, go take care of your grandkids. I haven't lost my mind to nothing, but you guys might, if you look at your grandkids, you're not dumb. You kind of look like a bad grandma in Valley City, not taking care of your grandkids. No offense. Again, that message goes on. Again, that happening here in Barnes County, state of North Dakota.
Ms. Rambo?
How is the fact that your kids aren't showering, how does that make the grandma look bad? It makes you look like a crappy mom that you were ever, on the drugs in the first place. Good for you for going into treatment. I'm not minimalizing that. But your mom is not the crappy mom in this situation.
Was that what happened?
That is true and correct. I did also put in an exhibit, or well, I didn't put in an exhibit, but my mom also did respond to those messages. So she truly threatened. She did threaten, or she responded with "I love you," and something in relation with the treatment. So is she truly threatened? I don't think so. She said she loved me, and she said that she would like to see me in treatment and that she cares about me. So with that, I don't feel there is, I think this is more of a mainly civil thing between me and my mom. It's not necessary. She did respond with, "I love you," twice now. So, I guess I don't have much more to say than that. Besides, I have been in treatment for the last 2 months. I wasn't evading. This this is really hard for me. I apologize. Sorry. And that's all I have to say.
All right, so with respect to the factual basis, those text messages, you did text message Jody Taylor, and you know Jody Taylor is protected by a court order, and you knew that court order was in effect at the time that you texted her, but she texted you back. Fair to say?
Yes.
All right, so I am going to accept your guilty plea. I'm going to find the same as freely, knowingly, and voluntarily and intelligently entered. The court finds an adequate factual basis to support the guilty plea. Mr. Jackson.
Your Honor, I did provide opposing counsel with an offer on the other case that she is represented on. It's kind of out of order based on that. However, the state's recommendation on this case is 360 days, first serve 30, credit 2 days actual, 0 days good time, 360 days of supervised probation with the standard Appendix A, $200 court administration fee, $100 facility improvement fee, $25 victim witness fee. And Your Honor, I would also be requesting that there be no contact under the Appendix A. However, I do understand that Your Honor usually doesn't like overlapping, disorderly conduct restraining orders, as well as these types of criminal restraining provisions. So I would leave that to your discretion.
So you're asking for 30 days in jail. She's got credit for 2, followed by almost a year of supervised probation.
Yes, Your Honor. Additionally, there was a previous conviction for violation of disorderly conduct restraining order back in 2023.
All right,
And that was a misdemeanor.
understood. Ms. Chisholm, your thoughts on sentencing?
Your Honor, I would ask if the court exercises discretion and impose a sentence that recognizes Ms. Rambo's proactive steps towards rehabilitation as she points out, Your Honor, she has been in treatment voluntarily at CRU since July 14th. That's something she did on her own accord. She did that for her children. She did that for her family as a whole, for herself. She recognized that chemical dependency and substance abuse has been the underlying cause of a wide variety of issues that she's had, Your Honor, and I commend her for doing that. Also, she did take responsibility here today, Your Honor, that speaks volumes about her willingness to address and take responsibility not only towards the criminal involvement here, Your Honor, but her own sobriety. Also, and while not entirely relevant, I do think it's important to point out, Your Honor, that she has had some issues with a former significant other that has also contributed substantially to her criminal involvement. And I'm hopeful that she has put that in the past as well, Your Honor. And so she's very actively moving towards a better life for her and her children. And so I would ask that the court please exercise some discretion with respect to the rehabilitation aspect of the sentence and perhaps show some mercy on her with respect to the incarceration side of things, Your Honor. Thank you.
All right, so before I ask Ms. Rambo about her thoughts, we're going to take up bail in file 171. Mr. Jackson, what is your thoughts on bail?
Your Honor, I believe in this case, bail was previously set. The first time the cash portion was $1,000. The second time it was $2,000. So, Your Honor, I'm asking the court the pattern to continue. I'm asking for $3,000 cash as well as an increase to the corporate surety aspect, asking for $6,000 corporate surety, and the conditions to remain the same.
All right. Ms. Chisholm, your thoughts on bail on 171?
Thank you, Your Honor. And I guess it would be somewhat dependent on what the court decides to do with respect to the other case. Because we did get an offer this afternoon on the case in which I represent Ms. Rambo. So depending on the court's sentence on 206, it is likely that Ms. Rambo would consider resolving the other case. With that being said, I would ask that the court consider releasing her on her own personal recognizance on 171 so that she can return to treatment and continue to address her sobriety. That's been her primary goal, Your Honor. I have not had any issues since I have been court appointed to Ms. Rambo. She's always maintained contact. We've always known where she is, what she's doing, where she's been. I understand there was a warrant that was issued. That was issued as a result of a violation of the bond at the very same time that I was court appointed to her due to some contact with the ex-boyfriend that I referenced during my previous argument. I would like to also point out, Your Honor, that she was released back in June or July from Cass County Jail without a drug patch on.
So basically, no contact orders don't mean anything to her because she violated the one with her ex and she violated the one with her mom. And she's going to continue violating because though you say she takes responsibility for everything that she does, that's only after she does things that she's not even supposed to do.
So that also created some 24/7 reporting issues right out of the gate for Ms. Rambo. But she has since, as I said, been very actively addressing her sobriety issues. And as the court knows, she did just take responsibility for this other case. So I would ask that the court consider releasing her on her own personal recognizance with respect to 171, Your Honor.
So, Ms. Rambo, before I impose sentence on 206, you have the absolute right to say anything that you want in mitigation of punishment, and I'm going to give you a chance to do that. In that case, you have waived the right to remain silent. And so, but you can say whatever you want. You can tell me I don't have anything to say. You can say I've already said it. You can say my attorney said it. You can whatever you want to tell me on 206, you can.
Yes, pick one of those options. The judge just helped you out, did you a big favor there. Pick one of those options.
On file 171, you remain presumed innocent, and things that you say with respect to 171 can still be used against you. You don't have to say anything in 171 about bail, but I'm going to give you an opportunity to say something about bail if you want. The state has asked me to essentially increase your bail by 50%. So, or 150%, I guess is probably a better way of saying it.
I
Bail
wouldn't be
was
able,
$1,000 cash, and then I moved it to $2,000 when we had previous issues, and now the state is asking for me to move it to $3,000. That's a separate decision than what I decide on the sentence. So I'd like you to address both if you want, and if you don't want, that's fine as well. Here's your opportunity to speak. Tell me anything you want.
I would just have to agree with my attorney. I have been actively staying sober 2 months, actually, in 2 days. So I've submitted to a urinalysis there. I passed it. And she is correct. I did get bonded or bailed out with no 24/7 patch stuck to me, and I didn't even think about it. And then I left and then went to treatment a week later. As regards to the bail or bond, I would also like the same. I'm kind of unhealthy right now. I'm trying to get my health in order. I have a back problem. I just want to keep working on my sobriety so I can be with my kids. That's very important to me. So with that, I'll leave it at that. Thank you.
In terms of the bail, the court is going to impose the same bail conditions as have been previously imposed. I'm not going to modify bail. Bail was set at $2,000 cash or surety. In that file it was $2,000 cash, or in the alternative, I'm looking back at the bail order. Well, we're gonna have to talk about this, I guess. So bail order was set on 6/26/2025, record index 33. Bail at that time was set at $2,000 cash or $5,000 corporate surety. In addition to the 24/7 sobriety program, I ordered both the drug patch and random urinalysis testing. So not one or the other, but rather one and the other. Additional conditions were imposed as well that were non-financial. Thereafter, there was a motion to revoke bond, and the court entered an order revoking bond on 7/16/2025. That's record index 51. At this time, I'm vacating that order. Bail, as set as record index 33, is reinstated. That bail order remains in full force and effect. So what that means for you, Ms. Rambo, is it requires you to appear in court. Your next court appearance on that file is October 7, 2025 at 1 p.m. at the Barnes County Courthouse in Valley City, North Dakota. It requires a patch to be put on you before release, and it requires you to report and submit to random urinalysis testing. If you are in inpatient treatment, the court doesn't have proof that you're in inpatient treatment. Your attorney can help you request a furlough from the 24/7 program or a temporary suspension of that program if you are in inpatient treatment for as long as you remain in inpatient treatment. Your attorney can help you with those things, but I need proof in my file. Otherwise, what it looks like is you're just ignoring what I ordered, and I don't want that to happen. All right? So if you're in an inpatient treatment, it's duplicative for the court to order you to do a urinalysis test and or a patch test. If you're in a sober living environment in an inpatient treatment facility and you're being tested and treated, I don't want to double up on services, but if I don't have proof that you're in a treatment facility, I don't know that's what's going on. And what it looks like to me is that you blew off my order. So I'm vacating the order, revoking bond, reinstating the bond that was previously ordered. You have a court date for that matter. And Ms. Chisholm, if you can please file proof that Ms. Rambo is in an inpatient treatment facility, we can readdress the 24/7 condition if necessary for as long as Ms. Rambo remains in that treatment facility.
Yes, Your Honor.
Any questions about that, Ms. Chisholm?
No, Your Honor.
Any questions about that, Mr. Jackson?
No, Your Honor.
All right, so now turning to the sentence on 206.
Can I do have more credit for time served, just so you're aware. I had 3 days in Stutzman and 4 days total in Cass. Just wanted to make you aware of that. It's not 2 days.
A total of 7 days.
Yep.
Mr. Jackson?
Your Honor, if she's asserting that that's the truth on the record, I have no reason to refute it. That's what it showed on the return, is what I believe I looked at. But that would be 7 days with an additional 1 day of sentence credit for good time. So
Total 8, 7 actual, 1 good time.
Yes, Your Honor.
All right. Does that change your recommendation in any other way?
No, Your Honor, it doesn't.
Does that change your recommendation, Ms. Chisholm, in any other way?
No, Your Honor.
And Ms. Rambo, is there anything that you want to tell me about that additional credit in light of the agreement between the parties that you have a total of 8 days credit?
No.
All right, so I've considered the sentencing factors, I've considered the purposes of the criminal code. I've also taken into account the nature and circumstances of the facts underlying the case, the nature and circumstances of the violation. Ms. Rambo, I understand you are perhaps in a difficult position with your family circumstances and your children. I understand you have alleged in previous proceedings that you are a victim of domestic violence and you have been trying to escape that situation. I understand that Jody Taylor is your mother, and she, at least in the past, have provided care for your children. And I understand the nature of the contact alleged in this case is seeking your mother to help you with your children, to provide care for your children. So the contact is prohibited. The law is the law. You violated the law. You admitted to it. But I understand where you were coming from as a parent. It doesn't excuse or justify the conduct. But
It doesn't excuse or justify the manipulation. Sorry, I really need to stop talking. Words are hard right now. Yeah, trying to manipulate your mother, asking for help would have been one thing, even with the court order in place. I mean, maybe if it wasn't done in such a rude and just entitled manner, maybe I wouldn't be so much against it. But it wasn't a, hey, can you help with the boys? Or hey, I really need your help. It wasn't that. It was, the boys aren't showering. You need to go over there and make them shower. And if you don't, you look like a bad grandma. What?
it is a factor I can consider under North Dakota Century Code Section 12.1 3204. It's that the conduct, although insufficient to establish a justification or excuse, tends to mitigate or excuse the conduct. The nature of the contact here, although still a violation of the court's order, is good intentioned, even though it is still a violation of the court's order. Ms. Rambo, you must understand that that order that disorderly conduct restraining order has a provision in it saying it doesn't matter if Jody Taylor consents to the contact. So even if she texts you back, I love you and I'm sorry and I want to take care of this, that doesn't make it legal and it doesn't make it okay. It doesn't prohibit the court from moving forward with judgment, but it is a factor I can consider. I applaud you for your efforts to try to get sober and that you have voluntarily entered treatment. I wish you would have told me that you entered treatment. And so instead of having to issue a warrant that has been outstanding for a month, it would have been nice to know that you were in an inpatient treatment facility, and it would have been nice to have taken care of that warrant earlier. All things considered, the court is going to fashion a sentence as follows: 360 days in the custody of the Department of Corrections and Rehabilitation. First serve 8 days. Balance suspended for a period of 2 years. 2 years supervised probation. Standard conditions of Appendix A. Credit, 8 days total, 7 days actual, 1 day good time, all future sentence reduction credit authorized by law. Again, balance is suspended for a period of 2 years. Standard conditions of Appendix A. Fees waived. Mr. Jackson has requested an order prohibiting contact with Ms. Taylor. He is correct. I don't like double dipping and having multiple orders prohibiting the same contact. I'm not going to require that in this case because there already is a valid and enforceable disorderly conduct restraining order in place. I'm ordering a diagnostic assessment as a special condition of probation. That diagnostic assessment must include mental health evaluation and a chemical dependency evaluation done by a licensed professional, whether that's South Central Human Service Center, Southeast Human Service Center, or some equivalent facility. I'm ordering you to submit to a diagnostic assessment within 60 days of entry of judgment. I'm ordering you to follow through with any treatment recommendations, both with respect to your mental health and your chemical dependency throughout the duration of your probation. My goal here, Ms. Rambo, is to rehabilitate you so I don't see you in County Orange again. I want to reunite you with your children, but in order to do that, you need to take care of yourself first and get your mental health squared up and get your chemical dependency issues squared up. So that's the purpose of the court's order. I also, if you have been in inpatient treatment, and this overlaps with file 171, file proof that you have been in inpatient treatment with the court within 60 days. That by itself does not satisfy the diagnostic assessment requirement because it's only half of what I asked for. But nevertheless, South Central or Southeast might say that that meets criteria for what they would do as part of the diagnostic assessment. So I want it filed so everyone knows what you've been doing and how things have been going. You're ordered to sign any release of information documents between yourself, the treatment provider, and probation to allow probation to communicate with your treatment providers concerning your treatment outcomes, namely diagnostic assessments, recommendations, participation and completion of those programs. Any questions, Mr. Jackson?
No, Your Honor, thank you.
Any questions, Ms. Chisholm?
No, Your Honor, thank you.
And If I haven't already ordered it, fingerprints and 206 are ordered as part of the judgment. Ms. Rambo, do you have any questions?
I don't think so.
All right, so with that, we are adjourned.
Thank you.
All
Is
right.
that just with the first one or the second one? Now I'm confused.
I reinstated your bail on the old file, and on the new file, I gave you time served and double the probation the state wanted.
Okay,
But no more jail, but double the probation because I want you supervised for a longer period of time. And I ordered you to basically get some treatment and follow through with it.
so what about the other one, the first one? I apologize.
The other one, you're being released because your bail that you previously posted is reinstated.
Do I go back? Do I put a drug patch on?
Yeah.
Or I'm sorry, I'm not understanding.
Talk to Ms. Chisholm. She will straighten it out. How about that?
Oh, okay. So I'm not being released today? I apologize.
So there's nothing holding you, but when you're released, they will slap a patch on you before you leave.
Okay, so I have to pay for the patch.
Yes, but I waived other fees.
I appreciate that.
All right. We are adjourned in that matter.
Thank you.
All right, guys, I'm going to stop for just a second because I realized that I didn't turn off my VPN and I have and I didn't want to do that in the middle of the video and have it kick the video off. So it should be all good now. Check. It looks hunky-dory.
Next matter the court's going to take up is a Lemoore County matter. Is Mr. Cerny connected? Mr. Cerny is not connected.
Your Honor, Mr. Cerny was just assigned at about 1:30. I did call him and leave a message.
Understood. Thank you. All right. So Lemoore County Court is now open, calling State of North Dakota versus John M. Merrill, 2025 CR 38. Present in court for the state, Attorney Fallon Kelly. Mr. Merrill appears by reliable electronic means with Stutsman County Correctional Center. Mr. Merrill, before court, applied for a public defender. The clerk, as the court's designee, reviewed the application and determined that Mr. qualified for public defense services and appointed Attorney James Cerny to represent Mr. Merrill. That happened at about 1:30 this morning. So Mr. Cerny doesn't appear has received notice that he is now assigned to represent Mr. Merrill. In this case, it is an initial appearance and bond hearing on cases involving felony matters. The court was informed that Mr. Merrill was taken into custody on September 9. So we are already pushing the 48-hour rule. And I can't continue the matter any further. I need to make a probable cause determination and I need to make a bail determination. Mr. Merrill, were you present in court when your rights were read?
No.
You didn't watch a video at the beginning of court?
Oh, this video right now today, yes.
The video that you watched.
Yeah.
So
Oh, I thought he's asking if I was already in court. No, yeah.
when I started court, you watched about
Yeah.
video. So you were present when that was played.
Yeah.
Do you understand your rights?
Yes.
One of the important rights you have is the right to be represented by counsel at every stage of the proceedings, including this one. You have applied for a public defender. The court has granted you a public defender, But because that just happened, it doesn't appear, your public defender has not appeared, and I don't think he's received notice. Because like I said, it was just granted at 1:30 this afternoon. Court started at 2. The clerk's office called Mr. Cerny's office and left a message, but didn't speak with anyone to inform Mr. Cerny that he had court basically on a half hour's notice or less. So I need to move forward because of when you were arrested, one way or another. It would be preference, it's the court's preference that counsel be here, but ultimately, I don't think he's received notice. And in light of how long ago you were arrested, I have to make a decision here on probable cause and bail within 48 hours of your arrest. So we have a few options. I can move forward today without your participation and simply determine whether probable cause exists and set your bail without your participation. Or you can waive your right to counsel for today's purposes only. I'm not going to be taking pleas in your case because it involves felony matters, at which time I would give you an opportunity to participate in the setting of your bail if you would like. How would you like to proceed, sir?
I don't even understand all this, but yeah, do whatever, I guess, whatever.
So if this,
So I don't get no lawyer, you're gonna move it, don't matter, you just said it don't matter what I say, you're gonna move forward with the proceedings anyway, so I mean, it's whatever, I guess.
so here's what I'm telling you. If you would have appeared yesterday, I would have continued your case until today at a time where your lawyer was present and he would have had notice. But because I have to set bail within 48 hours and I have to I have to determine probable cause within 48 hours, and your initial appearance has to happen within 48 hours, and I need to set bail as part of the initial appearance. I can't continue your case anymore because we're already pushing that timeline.
Okay.
So my options are move forward with or without your participation, because otherwise you won't have a bail set and you won't have a probable cause finding within 48 hours, which is required.
Okay.
So with that, you can either waive to counsel today and we can have the hearing without counsel participating. And if I set bail at an amount that you can't make, I'll allow you to have another hearing with Mr. Cerny as quickly as he's available. The rule technically doesn't require it. Or I can move forward without your participation. How would you like to move forward?
I guess we'll just move forward. I mean,
So are you waiving your right to counsel for today's purpose, sir?
I don't barely even know how to read. I don't understand any of this. So I mean, if I don't need a lawyer, I guess I don't need a lawyer if we're gonna move forward anyway. So I mean, this other guy needs to do something. I don't know. So I guess we're just gonna move forward.
Okay. So what I will treat that as is an assertion that he's not going to waive his rights, and that's 100% fine. Mr. Merrill has requested a public defender. Under the Constitution, he is entitled to a public defender if he financially qualifies. The court has determined he's indigent. Bail and the initial appearance is a critical stage of the proceedings for which he is entitled counsel. Under Rule 44 of the Federal Rules of Criminal Procedure, this is a critical stage. Under the Constitution, it's a critical stage. Nevertheless, the court has to determine probable cause and set bail. So I'm going to do that, frankly, without participation of either party. I have reviewed the charging document. I have reviewed the affidavit of probable cause.
I don't think the judge gets much choice. I mean, they assigned him an attorney a half hour before the hearing, but now they're on the heels of the must have bond set within 48 hours law. The judge has to proceed no matter what.
The court, having reviewed that affidavit of probable cause, finds probable cause for some counts and not for others. The court has substantial concerns that some of the counts appear to be duplicitous. And what that means is more than one count for the same alleged conduct. And so the court finds probable cause to support count 1, fleeing a police officer, Class C felony, count 2, count 4, the to-wit language is duplicitous. I think it's the same conduct relating to both counts. I find probable cause to support count 2, hindering law enforcement. Count 3, the court finds probable cause to support count 3. The court does not find probable cause on count 4 for the reason stated. It's duplicitous and overlaps the conduct or the charge in count 2. Count 5 relates to reckless endangerment for reaching speeds of 75 to 80 miles an hour on gravel. Count 6 relates to reckless endangerment concerning a semi taking the road ditch to prevent a collision while the defendant was driving at high speeds. And count 7, reckless endangerment, indicating that the defendant caused a vehicle to take the road ditch to prevent a collision without or while the defendant was driving at high speeds. After reviewing the affidavit of probable cause, there's substantial overlap between counts 5, 6, and 7, although I think count 5 overlaps 6 and 7. Court notes the affidavit of probable cause refers to 2 separate vehicles that were ran off the road or allegedly ran off the road. So the court finds no probable cause to support count 5, but does find probable cause to support count 6 and count 7. So with that, the court dismisses.
Your Honor, before Your Honor does that, may the state address the court on counts 5 and 2? Or I'm sorry, on 4 and 2.
All right.
Your Honor, when I reviewed the document after I had already signed it, it seems to me that the state would rather go with false information to law enforcement, count 4, rather than count 2 hindering because of the nature of the factual allegations. And so the state would ask the court to consider dismissing count 2 and leaving count 4 in place, which would still avoid the duplicity that Your Honor pointed out.
All right. So I'm going to find probable cause for either or. If the state is asking the court not to find PC on count 2 and would rather keep count 4 is a lesser offense. That's fine with me.
Thank you, Your Honor.
Any other comment on the court's order concerning probable cause?
No, Your Honor. Thank you.
All right. So I revise my finding. I find a probable cause on count 1. I do not find probable cause on count 2, finding it duplicitous with count 4. I find probable cause on count 3 and probable cause on count 4. I do not find probable cause for count 5. I find it duplicitous with counts 6 and 7. The court does find probable cause on 6 and 7. So what that means, count 2 and count 5 are hereby dismissed. The state is ordered to file an amended criminal information reflecting the dismissal and a proposed order on probable cause concerning the findings made on the record. And it can simply say, for the reasons stated on the record, the court finds probable cause on 1, 3, 4, 6, and 7, but no probable cause on 2 and 5. Then file an amended information consistent with that probable cause order, please.
Yes, Your Honor.
All right. And so, Mr. Merrill, what that means for you, and again, I understand that you're just sort of along for the ride here, but I am going to read you the charges that remain. I'm not going to ask for a plea of any kind. I'm going to inform you of the nature of the offenses and the penalties that are possible, court fees, the potential for restitution, immigration, and collateral consequences. Then I'm going to set bail at an amount that I find is appropriate. Again, because your counsel is not here, I'm likely to do that even without Mr. Kelly's participation, just based on the information that I know from the affidavit of probable cause. Because again, I think this hearing is going to have to be rescheduled or redone when your attorney is present. So, sir, the Lemoore County State's Attorney's Office charges you in count 1 with fleeing a police officer. The state alleges that on or about September 9, 2025, in Lemoore County, North Dakota, the defendant, John Michael Morrell, did commit the offense of fleeing a police officer in violation of North Dakota Century Code Section 39-10-71-1C, 39-10-71-2, and 12.1-3201 sub 4, Common Statute Table Number C99627. By then and there, the defendant was a driver of a motor vehicle and willfully failed or refused to bring the vehicle to a stop, or otherwise fled or attempted to elude in any manner a pursuing police vehicle or police officer when given a visual or audible signal to bring the vehicle to a stop, and at a time during the flight or pursuit, the driver willfully operated the vehicle in a manner constituting an inherent risk of death or serious bodily injury to a third person. To wit, said defendant did flee peace officers in a high-speed chase. The offense is a Class C felony.
Well, you know what it was, Your Honor. He did say that he can barely read. So he was just driving along. He didn't know the cops were chasing him, and he couldn't read the speed limit signs. He was just doing what he does. No crime.
Count 2, the court did not find probable cause for, so count 2 is dismissed. Count 3, in that count, the state alleges that on or about September 9, 2025, in Lemoore County, North Dakota, the defendant, John Michael Morrell, did commit the offense of criminal mischief in violation of North Dakota Century Code Section 12.1-2105 sub 1, 12.1-3201 sub 6, Common Statute Table Number L06627. Then and there, the said defendant drove through a cornfield, causing at least $1,000 in damage. This offense is a Class B misdemeanor. In count 4, the state alleges that on or about September 9, 2025, in Lemoore County, North Dakota, the defendant, John Michael Morrell, did commit the offense of false information to law enforcement in violation of North Dakota Century Code Section 12.1-1103, subsection 1, subdivision A, 12.1-3201, subsection 5, Common Statute Table Number C07441. By then and there, the defendant willfully gave false information or a false report to a law enforcement officer, which the defendant knew to be false. The information may have interfered with an investigation or may have materially misled a law enforcement officer. To wit, said defendant produced a bill of sale with the name Mike James Parker when asked for identification. This offense is a Class A misdemeanor. The court dismissed count 5 after not finding probable cause to support it. In count 6, the state alleges that on or about September 9, 2025, in Lemoore County, North Dakota, the defendant, John Michael Morrell, did commit the offense of reckless endangerment in violation of North Dakota Century Code Section 12.1-1703, 12.1-3201 sub 4, CST Code C00270. By then and there, the defendant willfully created a substantial risk of serious bodily injury or death to another under circumstances manifesting extreme indifference to the value of human life. To wit, said defendant did cause a semi to take a road ditch to prevent a collision while the defendant was driving at high speeds. This offense is a Class C felony. In count 7, the state alleges that on or about September 9, 2025 in Lemoore County, North Dakota, the defendant, John Michael Morrell, did commit the offense of reckless endangerment in violation of North Dakota Century Code Section 12.1, 1703, 12.1, 3201, subsection 4, CST Code C00270. By then and there, the defendant willfully created a substantial risk of serious bodily injury or death to another under circumstances manifesting extreme indifference to the value of human life. To wit, said defendant did cause a vehicle to take a road ditch to prevent a collision while defendant was driving at high speeds. This offense is a Class C felony. Against the peace and dignity of the state of North Dakota, dated this 11th day of September 2025, signed Fallon Kelly with Mr. Kelly's signature block. So you are charged with Class C felonies in count 1, count 6, and count 7. For each of those Class C felonies, the maximum penalty is 5 years in prison, a fine of up to $10,000 or both. The state has not alleged any minimum mandatory penalty except a requirement that you provide a DNA sample and fingerprint sample if you are convicted of the offense. Associated court fees for those offenses, those Class C felony level offenses, total $525. In count 3, you were charged with a Class B misdemeanor. Class B misdemeanors carry a maximum possible penalty of 30 days in jail, a fine of up to $1,500 or both. Court fees associated with a Class B misdemeanor total $250. State has not alleged any minimum mandatory penalty. There is a requirement that you'd submit fingerprints if you were convicted of that offense. Count 4, the only remaining count is a Class A misdemeanor. Class A misdemeanors carry with it a maximum penalty of 360 days in jail, a fine of up to $3,000 or both. Again, the state has not alleged any minimum mandatory penalties. There is a requirement that you would submit fingerprints if you were convicted of the offense. Court fees associated with a Class A misdemeanor total $325. For all of the offenses that remain, if your conduct caused a financial loss or injury to another person, the court can order restitution, which is an order that you financially make the victim whole. If you are not a United States citizen, a conviction for any of these offenses can result in significant adverse immigration consequences. If you were convicted of any of these offenses, it might also result in significant collateral consequences. The court is not required to explain collateral consequences to you because they are speculative and they are not generally imposed by the court. They're imposed by operation of law or by relationships with others. Sir, do you understand the nature of the charges and penalties as I've read them?
Yeah.
All right. So in terms of setting your bail, the court notes, Constitution provides all defendants are bailable upon sufficient sureties in Article 1, Section 11 of the North Dakota State Constitution. Rule 46A of the North Dakota Rules of Criminal Procedure contains a presumption of release on one's own recognizance unless the court believes that presumption has been rebutted and overcome by sufficient evidence or information before it that the defendant will not appear on an unsecured appearance bond or on a promise to appear. Here, the court finds that presumption of release on unsecured appearance bond is overcome. The allegations here in the affidavit of probable cause indicate Mr. Merrill allegedly fled from law enforcement, provided them a false name, fled at a high rate of speed in a dangerous manner, has an outstanding escape warrant out of the state of Montana, and was found with $30,636 in cash, which posed substantial concerns for the defendant to appear in court when directed in light of the nature of the flight and the risk of flight, the danger to the community, the defendant's apparent lack of ties to North Dakota, or at least the court is not aware of any ties to North Dakota, or in particular to Lemoore County. The defendant was located allegedly with a substantial amount of cash. The court has information before it that Mr. Fleck has allegedly escaped from Montana and fled that jurisdiction into North Dakota, which again pose significant concerns that the defendant will appear when required. Again, because Mr. Cerny is not present and he's been appointed to represent Mr. Merrill, I'm setting bail without Mr. Cerny and without participation of Mr. Kelly. And this case will be heard again tomorrow, and I will revisit bail at that time. But in the meantime, now, bail is going to be set at $100,000 cash, $500,000 corporate surety. Additional conditions: you must not violate the laws of any city, county, state, or nation. You must not leave the state of North Dakota without the advanced express permission from the court. You must maintain appropriate contact with your defense lawyer. That contact must be weekly because Mr. Cerny is a public defender. You must notify the court of any change of address, employment, phone number, or email. You must sign a promise to appear in waiver of extradition before release. You must appear for all scheduled court hearings and appearances unless excused by the court or by the filing of a proper waiver of appearance. Your next court date, sir, will be tomorrow. At what time, Ms. Strawn? At 11 a.m. Central. So court will be September 12, 2025, 11 a.m. The next court date after that is October 23rd, 2025 at 2 p.m. in the Lemoore County Courthouse in Lemoore, North Dakota. But again, we will recall this case tomorrow and bail will be revisited then. You have already filled out an application for court-appointed counsel. I've signed the bail order as it sits. And again, we will call this case again tomorrow when Mr. Cerny can be present and he'll have adequate notice to appear. In the meantime, bail set at $100K cash or $500K surety plus conditions. Mr. Kelly, any questions?
Your Honor, I wasn't able to hear that.
Mr. Kelly, do you have any questions?
No, Your Honor, thank you.
Mr. Merrill, do you have any questions?
No.
All right, that matter is adjourned. We will see you tomorrow.
Have a good day.
Good day.
This is just wholesome and cute and funny. The judge has court in recess right now.
The court is in a brief recess at this moment. You were placed into a breakout room in order to discuss the case ahead of time. Were you completed with that? You're ready for the judge to call when she's available, or do you need to go back into the breakout room?
Oh, breakout room will be necessary. Diane, you want to take it from here?
Well, no. Don't worry about that. We're not on the record. Judge
No,
recess
yeah.
at the moment.
Oh.
So if you just want to go ahead and wait, once judge is available, she'll come back in and she'll call it. Okay?
Sure.
Okay. Thank you.
I was just going to say, tell them that, that you're out.
Yeah, it's always weird too when they stick you in and then there you are. Da, 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 da.
Yeah. What were we supposed to do there?
Trying to think of something exciting to do in the interim.
Right. Yeah.
Although at least, this is a fairly quick judge.
Mm-hmm.
Some of them are not.
I've had maybe like the worst 10-day stretch. I mean, I've only been doing this for 4 months, so I'm really fresh. But this has been like the worst 10-day stretch in terms of how long I've had to wait for cases to get called. 33rd has just been an absolute mess the last week. I think I've spent a combined 4.5 hours waiting for 3 cases to get called in 33rd.
You're kidding.
It's insane. It's nuts. They just had, you've worked with Tom before, right?
Yeah.
Yeah. Tom just had to wait almost 3.5 hours about 2 weeks ago. He got on for an 8:30 and it got called right before noon.
I mean, I love the judges that just whip through this stuff because it's like, we all know, I mean, I understand sometimes MSDs, they stick at the end there, but I don't file an answer ever.
Yeah.
So what are we waiting for?
Yeah. We know what's going to happen.
Yeah. You know where it's going to go. I mean, it'd be different. I understand if I filed an answer and it looks like there's going to be argument, they push you to the end. But all of this stuff is like poof, poof. What takes so long?
Yeah.
But what do I know?
I did notice that they save the credit card cases for the end too. They want to get through the landlord tenant and the general contract stuff. I mean, I guess I understand it to a degree because it's so straightforward, but at the same time, it sucks when this is like the majority of what I do, you know?
Well,
So,
I guess maybe they figure that you can, I don't know, do something else while waiting, but I'm not good at that.
yeah.
I'm not good at the, some people are, I guess, but.
I'm getting better at it, but I mean, I've definitely fallen prey quite a few times to not really getting a whole lot done, just totally myself. So, yeah,
You like looking for the guy, working for the guys. I love the guys. I love Danny and Tom. Oh, Tom is so sweet. I hadn't had him for a while. They hadn't
Yeah.
given me any of you guys' cases. He actually sent me a little email and said, "How you doing? I haven't talked to you for a while." And Tom is so straight. You know, he's such a rigid little guy.
Yeah.
I was totally charmed because
Yeah.
I hadn't had his case on any of a case for probably 6 weeks or something.
Oh wow, yeah.
Yeah,
No,
it blows hot and cold. Depends on what's assigned me.
right.
So-
Yeah. No, I mean, I like working here. I like everyone I work with. You know, they're all really great people. I mean, it's definitely not what I expected to do. But I mean,
What did you do before?
well, so I was a contract negotiator at a software engineering company. That was my first like real legal job out of law school. I didn't pass the bar until the past February exam. So
Oh, you're a newbie.
I'm a newbie. Yeah. I P88474. I mean, yeah, I'm new. So yeah, not at all what I expected to be doing, but and it was definitely like at first I was like, you know, like am I made for this kind of thing? But
This is, I would call, I remember years ago when I started out, and I've been around for a long time. And an attorney I was working under, and he said, would talk about probate as being a gentleman's practice. This is a gentleman's practice, or a gentlewoman. It's civilized.
yeah,
Nobody screams, nobody hollers. I mean, being a sole practitioner for most of my career, like 45 years,
okay,
I've done a lot of criminal, you know, pounding on the table, kind of, it's kind of fun, but this is just very civilized.
yes.
Nobody's excited.
hmm
Come on, it's just money.
Yeah, well, it is just money, but then again, I mean, some people look at
And
it
it's,
a little
and
different.
in the main, despite what my clients think, it's small amounts of money in the main, very seldom over $5,000.
Right.
You know, they're just they're in a corner and they're trying to get out of it and do what they can.
Yeah.
So, but there's no use to the attorneys getting excited because we all know the road.
Exactly. Yeah. No, it's when you're dealing with with the imprel per. I was called a couple names on a mediation one time.
Well, pro people get a
Yeah.
little bit excited.
But,
Yeah.
But yeah. No, it's been really nice working here, and I've actually had a really nice run of defendants and other attorneys the last couple of days that have made me feel like I'm actually doing something that's good. You know, I'm like helping people out a little bit, maybe. So I don't know. It's kind of nice feel. I had that with one of my 1 PMs. I took an amount that was right on the edge of what I could probably accept, but I mean the way that it was working out, we wouldn't get payment for forever. So it's just I think it's the best possible outcome.
Well, it seems to be the kind of thing that I've noticed. I've been at this funnel for about 8 years, and it seems to be that either you get into it and you like it and you stick with it, or you fly quick because it's not what you were looking for. You're looking for something maybe a little more excitement or a little more, honestly, challenge. This isn't, you know, we don't get a whole lot of sticky legal issues.
Yeah.
But it depends on your temperament and what you like to do.
Yeah. I mean, I'm not the biggest fan of super in-depth legal research, so I think it's a good speed for me. I think, yeah, it was. I mean, that's just what it is. I'm not sure that I want to spend hours upon hours trying to make sure that my authorities are, you know, overruled by some obscure case that I don't know about. It's a lot of fun to me.
Yep.
So, yeah, I'll get bogged down in a motion to set aside or something like that real quick. But that's about as long as I want to do something like that. So
Yeah.
Yeah.
Where'd you graduate from?
Michigan State.
Michigan State?
Yeah.
Oh, well, I guess I'm Michigan State now. I graduated from DCL.
You're at UCL? Okay, cool.
Yeah, but they were sucked up by MSU. So
Yep.
I guess I'm MSU now. They actually asked me because of, my big certificate, they sent it to me and said, would you like to have it changed? And it's like, no.
Yeah.
That's where I was going to downtown Detroit and watching the hookers at night work the street over. It was a very exciting law firm. I love really. I used to have real estate at night. Burton, he was a lovely Burton title company, Professor Burton. But it was at like 9:30 at night, 10 o'clock. It was one of the later classes. And we'd sit on the second floor and you could look over a totally vacant, barren block, and there's the girls working on the next street over. Provided evening's entertainment.
Yeah.
It was fun because it was downtown.
Right. Yeah.
And it was when it's gotten more civilized now, but it was because it was fairly close actually by the Tiger Stadium, just the other side.
Yeah.
But now it's civilized and dignified, and they're in a college campus. So I don't know, maybe they still have classes off campus, but
No, I'm not sure, to be honest with you, but yeah, I mean, Detroit's gotten a lot better recently. My girlfriend goes to med school. She's at a Detroit satellite campus for MSU, so she's been down there, which is forced me to get down there a little bit. And I've made a complete 180 on Detroit. I used to just go down there for Lions games and get out. Now I'm down there all the time. It's a great place.
yeah. Well, I was never afraid. I mean, all these years, I had a office on the east side for a while, Mount Clemens, and then the east side. I would go down there. I've never been afraid of Detroit, no matter how crazy it got sometimes. Now it's really gotten very nice.
Yeah.
Put a lot of money into it and clean, it just was kind of dead for so many years.
Right. Yeah.
I was never afraid, but it was kind of dead. But now, hopefully, it'll stay where it's at and get better.
Hopefully, yeah. It's been great to see you.
So where is our judge?
That's
what's she doing? She's probably taking care of people that are sitting there. Although I don't. Oh no, it's Gypsy. So there probably are people in the courtroom. Well, I'm gonna duck out for a minute, and you can stare at the ceiling. And see you in a few minutes.
Sounds great.
All right, the 14B District Court is back in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. I hope you all know that you're being broadcasted all over the world as you talk.
You're kidding.
I'm not.
We got to tell your clerk to kick us in that little dupa for doing that.
Forgot about that.
Well, he's a very nice fella.
Yeah, she's great.
All right. The court will call the case of Capital One NA versus Matthew Piranello, case number 25C1040.
Good afternoon, Your Honor. Dylan Clark, P88474, here on behalf of the plaintiff.
Diane Segarovis on behalf of the defendant, P32106.
Thank you. All right, so we have a number of things before the court today, including a motion to withdraw, a motion for summary disposition, and a pretrial. However, we don't have the actual defendant. We only have you, Ms. Zacharias. Where's the defendant? Do you know?
Well, I work through a debt settlement company, and defendants don't like me very well personally. She has indicated that I believe she may be looking, this is a heads up for Dylan, that she's probably going to be looking at bankruptcy, but she doesn't want to put any more time and money into this case. So I've been asked to withdraw.
The he.
Yeah.
This is a gentleman, first of all. So you've been talking to a guy or a girl? You said she. So this is Mr. Matthew Piranello.
Yes.
Okay. And so I did get your motion to withdraw. The problem is that I have right now is the defendant's not here. So if the defendant is not present, then a default's going to enter if you're allowed to withdraw. You do understand that part?
Oh, yes, I do. I mean, she has been notified, and she would serve.
You keep saying
yes, I know. I'm having a problem today. The gentleman has been notified. And
okay.
there should be a proof of service of same in the file, to that end.
Says it was certified mailed on August 6th to him.
Correct.
And the motion for summary disposition, which is scheduled for today, was mailed to him as well, with today's court date on it, as well as a notice from the court was mailed to him on August 13th, indicating that the court date was going to be set for today. And it had in there both the motion for summary disposition as well as the motion to withdraw as counsel. Mr. Clark, do you have any response to the motion to withdraw? Let's start with that.
None, Your Honor.
All right. Given that, then I will allow you to withdraw from this particular matter. So the motion to withdraw is granted, and I'm going to sign that at this time. And you are seeking to withdraw before the other matters are heard, is that
Yeah.
correct? All right.
Yes.
All right. And now, as far as the motion for summary disposition and a pretrial are concerned, Mr. Clark, are you asking that I simply enter a default in this case, or do you want me to rule on the motion for summary disposition?
I mean, I'm of the opinion that it's best to have this rest on the merits as opposed to going through default.
Very wise, because if it was just a default, the defendant could file a motion to set aside the default. Whereas if it is a judgment that stands on its merits, it's a little bit more difficult.
So I mean, I can keep it brief.
I have read the motion. It is a very simple motion based on a credit card debt and failure to pay. So it is a C10 and a C9, and I will grant your motion based on the merits.
Very well. Thank you, Your Honor. I believe there was a proposed order in the packet. Will you accept that, or do you want a new one submitted?
I have signed it, and your request is for judgment in the amount of $2,251.88, $2,102.48 being damages, and $149.40 in cost, correct?
Perfect. Yep.
Right. I have signed that. And we're all set.
Very good.
Have a good day.
You too,
Oh.
Judge.
Bye.
I didn't realize we were going to be providing entertainment.
Yeah.
I think you did. I really do think you did, especially the comments about the prostitution and about all of that was good. Have a good day.
Thank you.
Very educational, very informative of what Detroit was once like when she went to law school. All right, guys. Thank you for coming and spending this time with me. I'm sorry that I'm sorry that I am not more entertaining tonight. Maybe when I can breathe and laugh again. Hello, PH Jess, honey. I love you. Thank you for making it. Thank you. Absolutely trying. You guys are the best. Be safe, be well, sleep sweet, and much love.